Because he says,
which one comes first? Forgive me. Which one comes first? His appointment as a public officer or his appointment as a judge?
He's a public officer as a judge.
By virtue of being a judge.
Yeah.
He's a public officer by virtue of being a
So
judge.
which one should? Which one under which of the agencies does he stand as what?
That's what I'm saying. It's very clear. It's not even because I'm saying it. Because no matter even what the Constitution or anybody says, it is what the courts interpret that Constitution to be that it is. That is the law, even if we disagree with it.
Agreed.
Currently in Nigeria today, the position of the law is as stated by the Court of Appeal. It has not been overturned. It could be, I might not be. But the point is that as of today, as we speak, the 18th day of January 2019, the position of the law is that the procedure of trying to arraign the CJN because of his failing to complete go offer some information, or to have commenced by the petition of going straight to...
You know the problem I have with what is going on?
Let me
finish, then you take it from there.
By the petition going straight to NJC. From there, it could now come to CCT. And I even went further in my first submission to say that even the CCB having approached the CJN and he replying them according to them and saying that, oh, I missed that, that's why I completed in 2016. That is to say he had admitted. Because you put it rightly what the schedule says, setting up this and then what can come to CCB. Automatically, by virtue of that, because the word there is shall not be necessary, shall. That is, CCB will no longer have the legal right to refer that matter to CCT once there's an admission in writing.
Now, let's look at it this way. Section 6, subsection 6 of the 1999 Constitution gives the power of judicial review to the courts. Okay? NJSC, National Population Commission, INEC, Federal Civil Service Commission, and other bodies are bodies created by Section 153 of the Constitution. Section 158 grants them independence for their core responsibility. Section 292 just talks about the same thing. Now, there is nowhere in the Constitution where a provision is made that before a judicial officer can be put on trial in a court, okay, you must first of all go to NJC and have. So what they are trying to do is to go through the back door and grant themselves immunity that the framers of the Constitution did not deem it fit to give them. And look, let's look at it from this perspective.
So the Section 292, for instance, talking about the process of removing a judicial officer. Yes.
Now let's look at it this way. And you don't have that provision there that says you must first of all do this. But look, you know the issue. Let's look at it this point. That for whatever reason, there's a petition against a judicial officer. Okay? And for whether it is wrong or right, the NJC decides that it is not worth looking into it.
Are you saying your interpretation of Section 292 is that they had to proceed to the CCT first?
That's not what I'm saying. I am saying that the CCT, the Code of Conduct Tribunal, the Code of Conduct
Section 292
was created.
I'm talking about Section 292. What's your interpretation of Section 292?
That
Section 292, what's your interpretation of that?
Look, what I'm saying is, it is under that section. It's not required that you must first of all go to the NJC to remove Yes, you don't have to.
Is that your interpretation?
You don't have to.
First of all, you don't just wake up and try to remove somebody. You have to give reason what you to remove it.
That's not
so if, for instance, you sent a petition to Senate, because that's 292, removal of such principal officers like CJN. You don't just wake up and say, please, Mr. Saraki, I want people to get together and remove a CJN. You will send something to them. And when you send it, naturally, even they themselves might say, look, you know what, let's send this into the appropriate people who have the expertise to look at it, and then they make a recommendation to us. So that's a different matter. The law doesn't say, 292 doesn't say it must go to NJC or to anybody, to even police, for that matter. But what I'm saying is what my learned friend is doing here is he's expressing his own opinion. I've already said what the law is, and that is the point. My personal opinion, my inclination, my feelings are irrelevant.
I am
okay, we need to go to break, gentlemen. Don't worry, we'll come back to this in a moment. Don't go away. All right, welcome back to Sunrise Radio. You got a question?
Yeah, I just want something clear because I'm considering the layman, I'm considering the Free Readers Association of Nigeria, I'm considering student lawyers and all of that who are wondering what's the dichotomy between the functions of the NJC and the function of the CCB, CCT now. So I want this to be clear in the interest of all. The CJN is being tried on what platform? As a public officer or as a judicial officer? Where is the fusion? Where is the dichotomy? Otherwise, it will seem like one of the two, NJC or CCT, CCB, is not necessary.
Correct?
Okay, like I said before, the CJN is a public officer by virtue of being a judge.
Okay.
When he was an honorary lawyer, nobody gave him any form to fill.
Okay.
So now by becoming a public officer, he becomes subject to CCB.
By becoming a public officer.
Yes. But you see.
And what are the things required of him as a public officer?
Declaration of assets.
Okay.
Yes.
Which is what he's being questioned
which
for.
is the issue.
Okay.
But now, because it is fused by virtue of the office, his office is such that is what makes him this. So it's fused. So when you want to try him on the issue of declaration of assets, not because Kenneth Odedika is saying it, but because the Court of Appeal has said it, not me. And no matter what I feel, the law is the law. And that is the law today in Nigeria. So Court of Appeal has said that for such matters, you must bring the person to National Judicial Council first. Before, so that, as my friend used the words, so that the clerk of judge can be removed first before you can now deal with him the other way. Okay. That is what the law is as at today.
If it was a permanent secretary in an office,
yes,
or in the executive or the legislature, would the same rule, would the same procedure apply?
Okay. No. See, if you was a permanent secretary or even a minister, it is not the same thing. This is what, like I told you, my personal feelings are totally irrelevant, even if I don't agree with it. But my job as a lawyer is to when I'm being asked questions like you said, for the sake of our student lawyers and all that, my position is this: the law says that the law says, as stated by the Court of Appeal, says that for you to take this person to any other tribunal, which includes court, any other such judicial, you must take the person first to CCT in this. And that particular judgment we're talking about made exception to certain criminal acts like murder, stealing. Clearly, they said it there. The judges stated clearly that when such offenses are committed, then this NJC does not come in.
Chamberlain, can you just imagine for a moment that we have somebody being accused of a criminal offense who is a judge? And I'm not talking of the CJN. And for whatever reason, the NJC says, we don't even want to look into it. We're not going to prosecute. Can you imagine that the Constitution or the framers of our Constitution would have envisaged a situation where a situation like that will be forced on the security or the government, that you cannot prosecute a crime that has been committed because the person belongs to a special club of untouchables? That couldn't have been the intention of the framers of our Constitution. What they have done here is to expand, okay, and an attempt at power grab for judicial officers to say, look, we are above the law. You can't even inquire into what we are doing, or except to find ourselves guilty for you and say, come and look at us. And that couldn't have been. We have a situation in the Constitution where a body, also established by Section 153, 158, given the same power, has been given clear powers to do certain things, okay, as against another body that is created by the same Constitution, by the same session, and was not given that power to do those things. But the area then saying that, by that judgment, saying that unless the other body who does not have the express power does that and that and that, the body with the clear power cannot do anything.
Well, that's
that
how
couldn't have been the intentions of the framers of our Constitution.
That's how far we can go. Mr. Kenneth Odedika and Curtis Adigba, both legal practitioners. Gentlemen, Thank you for coming on this morning.
Thanks.
And that's the show today. Well, thank you all for watching. We'll be back next week. I'm Chamberlain Uso.
I'm Ayo Makine. Enjoy the rest of your weekend.
The views and opinions expressed by guests on this program are those of the maker and do not reflect the views, opinions, and endorsement of Channels Television.